One of the most important issues being litigated in the Brian Walshe case right now is whether Brian Walshe will get access to the federal materials that were provided in the Karen Reed case. Now, why does Brian Walshe want access to the federal materials? Well, very simple. Because the same players that were involved prosecuting and investigating Karen Reed also were involved in prosecuting and investigating him. So if the federal government dug up some dirt on some of the investigators, like Michael Proctor or Yuri Buchanan, well, that's something that Brian Walshe is going to want to know. Maybe there's some text messages that they found on Michael Proctor's phone that have to do with Brian Walshe. Who knows? So this is why he wants to get access, or his team, his defense team, wants to get access to the federal materials. And this is not an issue that's going to remain just in Brian Walshe's case. All of the criminal defendants right now in Massachusetts that Michael Proctor or Yuri Buchanan or any of the same players that were involved in Karen Reed's case were also involved in their case. All of their attorneys are going to be making the same types of motions, asking the judge for access to the federal materials. So they really got to figure out what to do about this conundrum. Well, really all they have to do is watch this video, because we're going to explain what Massachusetts law says about this specific issue. So before we jump into the case law as it relates to this specific issue, we have to understand that the problem here is that the federal government, they made the prosecutor and the defense team sign a federal protective order, which means that the federal government said, we're not just going to let you do whatever you want with this material. We are only allowing you to look, even just to look at this material and use this material as it relates to your prosecution or defense of Karen Reed. That's it. So as soon as that case is over, you're not allowed to even look at that material anymore. Forget about use, right? So you can't even review. This is what we heard a couple of hearings ago by ADA McLaughlin, that we can't even look at this material now to see whether there's anything exculpatory for Brian Walshe, because I'm not allowed to look at it. I'm bound by this federal protective order, which I signed. So even though I've got the file sitting in my office, I cannot look at it. Not allowed. Federal government finds out I did that, then they may have my head. I don't know. I don't want that. I don't want that trouble. So what should we do in that type of situation? That's the conundrum that the courts are finding themselves in right now, because the prosecutor may have seen, or there may actually exist some exculpatory information for Brian Walshe or any of the criminal defendants that have to do with Michael Proctor and Yuri Buchanan or any of the other players. And the prosecutor is going to say, look, I know that I have Rule 14 obligations to turn this stuff over and Brady obligations to turn this stuff over, but I just simply can't because I'm bound by this protective order. So I've got this friction. What should I do when I'm kind of bound by two different sets of rules? So that is the issue that the courts are dealing with right now. And don't worry, by the time that this video is over, it's going to be very simple. You're going to understand perfectly, because here at BCU, Brother Counsel University, nothing is complicated. We break everything down, and everything's going to be very simple for you to understand and follow as this case continues. So the first thing that we have to understand when coming into this issue is that we have to understand the idea of two systems, right? There's the state system and there is the federal system. Okay, so how does this all work? It's not that complicated. Don't run out the door yet, okay? And don't shut off the video yet. Definitely don't do that. And if you haven't yet, you should definitely subscribe, because there's a lot of cool stuff that we talk about in this channel. Okay, but what happens here is that the state system and the federal system are two separate systems operating in the same country. Okay, so a very simple example would be like your favorite sports team. So let's say, I don't know, Detroit Tigers or Boston Red Sox, whatever. So let's say you got these two teams, and they play. Who do they play? They play, obviously, these players play for that team, the Detroit Tigers or the Boston Red Sox, but also the Detroit Tigers and the Boston Red Sox are part of another organization called the MLB, right? So the MLB, and then if you want to be part of the MLB, so then you have to follow certain rules. The MLB may have certain rules that each team has to follow, and not only each team has to follow, but each player has to follow. You want to be part of this system? You want to play in our organization called the MLB? Well, there's certain rules you got to follow. And the MLB has the right to decide their own rules. They don't have to consult with the teams. You want to be part of our organization? Then you got to follow these rules. Okay, that's how the MLB operates. Well, then each team operates a different way also, right? If you want to be a Detroit Tiger, maybe there's certain rules about how you dress. Maybe there's certain rules about how you come to the game, or your facial hair, or I don't know, any other rules that they may make for their individual players that play for their team. Does the MLB have any input on how the Detroit Tigers decide to manage their team and rules that they have for their players? No. They can have rules for them, their own organization, the MLB, but they're not going to micromanage every single team and say you have to have these certain rules with these teams. No, that's not going to happen. Okay, so think about it as the state system as being each individual team having their own rules for their own players. That's the state system. The federal system is like the MLB. The MLB can have also rules about that generally govern being in the MLB. Now, where it gets a little bit interesting and slightly complicated, I should say, is where, let's say you have a federal rule which says you're not allowed to possess marijuana. Okay, so that is a federal rule actually right now. On federal law, you are not allowed to possess marijuana. But some of the states are going around legalizing marijuana. So if you're in a state and you're smoking marijuana or hanging out with marijuana, well, there's no crime in those states. But according to the federal government, it is a crime. So if you know that there's a federal agent looking at you, then you probably shouldn't do it. But if you just have some state cops looking at you, no problem. They can prosecute you. So you see how this works? Okay. So the federal system has these documents. They did this investigation. So it's really their documents. They have it. They can do with it what they want. So they don't have to give it over to the states if they don't want. And if they give it over to the states, they give it over, in this case, they give it to Massachusetts, well, they can impose certain restrictions. You're not allowed to use it for this and that and the other thing. Well, here's where it gets a little issue, is that when you have a prosecutor who knows that there's Brady exculpatory information or evidence, which can really help the defense, they have their own ethical and moral obligation to turn that stuff over. So that's where this friction starts to arise. Okay, so what should they do in this type of situation? Well, we just had a motion that was filed recently about this specific issue, and they cite a case. And of course, what we're going to do here is talk about the case. We're going to look up the case ourselves. We're not just going to trust the defense here. So this is the defense in Brian Walshe, and this is what they filed. And don't even get me started about this font. I don't know why people still use this old font. This is like the font from typewriters. I don't love it, but okay, this is what they want to do, then that's what they can do. So here it comes. And it's very, very short, and then we're going to get into the case law. Now comes counsel for the defendant, Brian Walshe, and provides citation to Commonwealth versus Liebman. And you see it says Liebman 1, and then another Commonwealth versus Liebman, another site, which they call Liebman 2. So now in case you're making a dart for the door, don't. Okay, this is not as complicated as you may think it is. Liebman 1, Liebman 2, federal system, state system, forget it, I'm out. No, stay right with us. Everything's going to be fine. Liebman 1 and Liebman 2, this happens a lot of times where a case will go up on the same case will go up on appeal once, and they'll make a certain decision, send it back down, and then the second time there's another decision that has to be appealed. So the same case name, same case, and it gets appealed again. So that's all it is. Liebman 1 was the first time it was appealed. Liebman 2 is the second time it was appealed. So we have to understand what happened in both cases. So, in support of his prior motion entitled Motion for Relief Regarding Federal Materials in the Possession of the Commonwealth, the matter is scheduled for a telephone status conference today at 2 p.m. Okay, so they talk a little bit about Liebman in this motion, and this is basically where they're saying, look, Judge, this is the case that controls this issue. And therefore, all you have to do is read this case and follow what this case tells you to do. And if you follow it, then that's all you need to do as the judge, and you're good to go. Then the issue is put to bed, put to rest. So we have to start looking at what does Commonwealth versus Liebman say about this specific issue. So let's go through what happened in Commonwealth versus Liebman. So this is the first Commonwealth versus Liebman 1. Okay, this is the first time it was appealed, and let's see what happened in this case. The principal prosecution witness was Milton Schnaff, also known as David Feathers. Okay, so this was one of the principal witnesses in this case, who testified to the following facts. The defendant, probably Liebman, a Massachusetts attorney. So the defendant here was an attorney. Okay, so don't get this confused out. He's an attorney representing somebody else. No, the defendant in this case was an attorney. And this witness was Milton Schnaff, also known as David Feathers. So the defendant, a Massachusetts attorney, performed legal services for Schnaff and participated in Schnaff's business operations, including the operation of a number of fast food restaurants. So you've got this guy, Schnaff, who's also testifying right now against the defendant, but at one point they worked together. The defendant was an attorney who worked and helped Schnaff. Why? Because he had a business. A lot of times business needs lawyers. And he also had a number of fast food restaurants. Okay. Early in 1975, at the defendant's instigation, Schnaff added Stanley Olatowski, a paroled bank robber, to the payroll of one of the restaurants. Okay, so you got the attorney who's working with Milton Schnaff, who owns these fast food restaurants, and the defendant, the Massachusetts attorney, says, it's a good idea to add this guy, Stanley Olatowski, who's a paroled bank robber, by the way, to the payroll of one of the restaurants. The three planned a bank robbery. So who are the three? Well, Milton Schnaff, the defendant, Liebman, the attorney, and this Stanley Olatowski. Now, they planned a bank robbery, which was carried out on February 26th, 1975 by who? Well, it wasn't carried out by the attorney. The attorneys usually are not so good at robbing banks. But it was carried out by Olatowski and two other men, Griffin and Santagello. During the robbery, Schnaff was in the office of the manager of the bank. So Schnaff was there, but it wasn't carried out by him. It was carried out by Olatowski and two other men. And now you got Schnaff testifying against Liebman, saying, hey, don't think that he wasn't part of this. He was part of this. He was just involved in the planning, perhaps. The other major witness for the prosecution was Deborah Hahn, manager of one of the Schnaff's restaurants, who was having an affair with Schnaff. Okay, so you got Schnaff, again, who's the owner. He was having an affair with Deborah Hahn, who was the manager of one of the restaurants. And she was also testifying. She also testified against the defendant here, the attorney who was the allegations are that he was part of the conspiracy to rob the bank. She and Schnaff testified that she was informed of the robbery plan to provide Olatowski with an alibi. Both also testified to meetings and conversations with the defendant before and after the robbery. So they're testifying, yeah, we had meetings with this attorney who's planning this bank robbery with us, and we had conversations with him, and he was absolutely part of this bank robbery conspiracy. Apart from the testimony of these two witnesses, there was no case against the defendant. So this is it. These two witnesses are the star witnesses. Without them, there is no case. None of the three bank robbers testified. So there's Olatowski and the other two men, Griffin and Santagello, they didn't testify. So it was just these two people, Schnaff and his manager, who he's having an affair with, Deborah Hahn. Schnaff and Hahn testified under promises that they would not be subjected to state prosecution. Schnaff had pleaded guilty to a federal crime for his part in the robbery and had been released from prison after serving 4 months and 7 days. So he's got a nice, sweet deal there. So that is what happened here. Now let's see what they're considering. What's the issue on appeal? We consider first, there's a number of issues, like a lot of times happens, but we're only going to concentrate on the issue that has to do with, what do you know, Brian Walshe's case, right? Why should we talk about all the other issues? I'm sure you do want to, and maybe in BCU, we will talk about the entire case. But for this portion of the BCU, we're just going to talk about the issue that's relevant to the Brian Walshe case. We consider first the denial of the defendant's efforts to secure the federal grand jury minutes. Okay, so what happened here? The defendant, this attorney, who knows his way around the courts, realized that there's a federal grand jury that went on here. So he wanted to get the federal grand jury minutes. So here again, this case is in state. This is a state case. He's being charged with this bank robbery in state court. But he also knows that there's also a federal charges that were going on here. And he wants to get some of those federal grand jury minutes. Very, very similar issue here, right? It's like federal materials. Now, there's no protective order over this federal grand jury minutes, which we'll see whether it makes a difference or not. But this is what essentially he wants. He wants the federal grand jury minutes. And he was denied those efforts. So his efforts went denied. He tried to get these federal grand jury minutes, which have to do with the same people that are testifying against him. In this case, these two star witnesses, they also testified in the federal grand jury, and he can't get a hold of those minutes. We then consider his other assignments of error and conclude that there is no reversible error apart from the problems posed by the federal grand jury minutes. So anyway, the most important issue here anyway is the federal grand jury minutes. So let's see what happened here. The federal grand jury minutes. Olatowski was arrested the week after the robbery. He was tried for the robbery in a federal court, but was found not guilty. Schnaff fled to Florida on March 9th, 1975, leaving his restaurants under the control of the defendant. Again, the defendant who was the attorney. Beginning on March 11th, 1975, Hahn testified before a federal grand jury. So they got Han. Remember, Han was the girlfriend, the one he was having an affair with, one of the managers of his restaurant, the two star witnesses, Schnapp and Han. So Han testified before the federal grand jury. Later, Schnapp and the defendant testified before the federal grand jury, and the defendant was informed that he was a target. The investigation by the federal grand jury ceased early in 1977 without the return of a federal indictment against the defendant, and the state indictment now before us was returned in June 1977. So the feds did an investigation, decided not to indict anybody, but the state decided to indict this defendant. The defendant sought access to the federal grand jury minutes by a proceeding in the federal court. So he went to federal court. So he didn't even make the motion in state court. He went to federal court. And he said, hey, guys, in federal court, filed this motion. I'm in federal court. I need these federal grand jury minutes because it relates to the same exact case, but I'm being prosecuted in the state court. But was denied access to anything but his own testimony. Thereafter, he sought access to the federal grand jury testimony of Schnapp and Han through a second proceeding in the federal court and a variety of motions in the state court. So now he filed both in state and federal court. He really wants the testimony of Schnapp and Han that was in the federal grand jury, including finally a motion to dismiss the indictment. All were unsuccessful. At trial, both Schnapp and Han admitted that they had lied to the federal grand jury. That's another nugget of information there, right? Okay, well, guess what? They don't have the transcript or any sort of minutes of what happened in the federal grand jury. So this is where the court makes its decision, so we're going to skip a little bit. Under federal law, the release of federal grand jury minutes in connection with a state judicial proceeding apparently requires a federal court order. So you're required to get a federal court order under federal law. So if in federal law, you want the federal grand jury minutes, well then, if you want to follow federal law, so think about this as, again, the MLB, you want to get something from the MLB, well, you have to follow the MLB laws. And the MLB laws, in this case would be the federal laws, would say, you got to get an order from us, which would mean that you have to have some sort of motion or some sort of order that says, okay, we could give you the federal grand jury minutes or anything else. We, of course, is talking about the state. So the state is saying, we, of course, cannot decide when such an order should be issued, but we note that there is federal authority for such an order. Continuing down, if the federal court in the present case refuses to send to the state court the requested transcripts of the federal grand jury testimony of Schnapp and Han, presumably the refusal rests on adequate reasons of security. And now that's very important, that line. Okay, so this is the state court saying, well, the federal courts did not grant this motion or did not allow this motion, as they say in Massachusetts. The federal court said, no, we're not giving you the federal grand jury minutes. I'm sorry. I know you did everything right. You went to the federal courts, you made a motion, but we're not giving it to you anyway. And since we don't have an order, we're not giving you this order. So now, sorry, you can't get it. Now, why do you think, this is the state now talking, why do you think that the federal government said we're not going to give you this order? Presumably because there was adequate reasons of security. I mean, they had very good reasons why not to turn over this information. So that can be analogous to a federal protective order. The same way you have a federal protective order which says, we don't want this information to go anywhere further. We don't want it to go any further. Why? Most likely because of reasons of security, right? So it's really drawing a very similar parallel between the reasons that are in this case, Liebman, and the reasons that are in the Karen Reed case. And also the Brian Walshe case, right? So in that event, the state indictment, so again, in that event, meaning if the federal court decides we are not giving you this information, sorry, as much as you want it, but we have security concerns that we're not going to give this information to you, well, in that event, the state indictment of the defendant is to be dismissed with prejudice. With prejudice. Remember Robert Alessi saying with prejudice, always making a mistrial with prejudice. That means that they cannot bring this case again. That's what it means. So here is where the court is saying very clearly, if the federal government does not turn over this information, for whatever reason, they may have the greatest reasons in the world, but if they don't turn over this information and it's exculpatory, well, guess what? The state must dismiss the indictment with prejudice, and they cannot bring it again. Now, If access to the federal grand jury minutes is permitted by a federal court, any restrictions placed upon that access, such as a requirement that the state judge make a preliminary examination in camera, must of course be scrupulously observed. Meaning if the federal government says, okay, fine, we're going to give you this information because, we see what you're going to do, state. You're going to dismiss the indictment with prejudice. And maybe the federal government has an interest also not allowing people that could be guilty of a crime running around because of this technicality or because of their own security concerns. Well, then the federal grand jury can say, the federal government can say, or the federal courts, same thing, can say, well, okay, we'll give you what you want, but before you use it, I want the judge in the state court to review everything in camera. No one gets access to this except the judge. And the judge can then make a determination. Otherwise, continuing in this opinion, otherwise the case should proceed as if the state grand jury minutes were involved. If the minutes might create a reasonable doubt that did not otherwise exist, a new trial may be appropriate. If they do not, the verdict and judges may be permitted to stand. So, what they're saying here is that if, and again, this is the state talking about what the federal government could do if they want. This is like the state saying, hey, this is what we perhaps suggest maybe you should do, but this is a good idea, which is that the federal government, federal grand jury, the federal court order, federal courts will give over whatever they're asking, not subject to any protective orders, but subject to the judge reviewing it in camera and then making a determination whether some of the information that is found in the federal materials could potentially create reasonable doubt. If the minutes might create a reasonable doubt that did not otherwise exist, then you should order a new trial. Right? That is what this judge, this court is saying. This is what the state court is saying. That's a good idea what to do. So, what happened in this case? Okay, you can read the rest of the opinion if you want, but we're just going to move on to the Liebman 2. Okay, so this is Liebman 1. Then what happened is that the judge did review the material and said, none of this would have been exculpatory anyway. It would not have created a reasonable doubt. So therefore, everything just stands. And all of this was just a lot to do about nothing because I looked over the materials and there's nothing here. Sorry, buddy. Nice try, but we're not having a new trial here or not dismissing the indictment, obviously. Well, then you have Liebman 2 because after the judge said that, well, of course, they appealed it again and say, hey, that's not fair. We think that there may be some materials there that actually would be exculpatory and maybe would create a reasonable doubt. So let's see. Now, so it goes back up on appeal. So the judge goes back on appeal, and then let's look what happens. After the district attorney applied to the federal district court for release of the testimony, the federal court transmitted the grand jury testimony of these two witnesses to the superior court. So they did follow exactly what the court said to do, the state court said to do. They said, okay, we're going to give you the grand jury testimony, and then you are supposed to look at it yourself. The judge then made the testimony available to both parties. On the defendant's motion, the judge held a hearing to consider the potential effect the absence of these federal grand jury minutes had on the defendant's trial. So what happened here was they released it to the judge gave it to both sides and said, okay, you review it and then come to me and have argument about whether the materials that you see from the federal grand jury, you can make an argument whether it would have created a reasonable doubt. So they did this. They had the argument, and the judge concluded, continuing now from the opinion, the judge concluded that this testimony could not create a reasonable doubt that did not otherwise exist. So remember, that was the whole basis for this was, well, you review it in camera or you review it with the attorneys, and that's what the decision here was, so that you review it amongst yourselves, and then you decide whether there's reasonable doubt, whether there could be reasonable doubt here. And the judge said, sorry, there's no reasonable doubt. However, so now they appealed it again, and this is what this court says, again, on appeal. However, from our independent review of the testimony and the trial transcript, and based on the standard we set forth in Liebman 1, we conclude that this testimony might create a reasonable doubt that did not otherwise exist. Accordingly, we vacate the order denying a new trial. So now finally they said, okay, we let you, we tried to let you do the right thing, but you're not doing the right thing. So therefore, we are vacating your order, denying the new trial, and now there is going to be a new trial, and they will be able to use the federal materials now. So that is what happened in the Liebman case. What do you see, though, clearly from here? And again, we'll just point you back to what it said right here. is that, again, if the federal court in the present case refuses to send to the state court the requested transcripts of the federal grand jury testimony of Schnapp and Henn, presumably the refusal will rest on adequate reasons of security. Too bad. You may have the greatest reasons in the world. You may have a protective order that you signed. In that event, the state indictment of the defendant is to be dismissed with prejudice. With prejudice. Okay, so you see what, according to Lehman, which is pretty clear, and this is what the defense brought up, is that we get to see those federal materials. At least the judge should, the prosecutor definitely should, and the defense should be able, we should be able to look at all those federal materials. And then if we're not able to, and if you're not able to provide them to us, well, then the indictment should be dismissed. And that's not something that I don't think the courts want. They don't want Brian Walshe to walk free now. They've got some very strong evidence against him, definitely those Google searches. So what seems to me is that if they're stuck with this not turning over the federal materials, there may, and the case goes on, and it doesn't get dismissed, does not get dismissed, well, then Brian Walshe can have a very strong appeal here saying, well, we didn't get these materials. Maybe there's something exculpatory there as relates to my case, and therefore I should get a new trial. So we'll see what happens here. But I think we see from these cases pretty clear from Lehman 1, Lehman 2, that what the process should be here. And they should be able definitely to look at the federal materials, and the federal government should agree to turn over the information and then allow them to look at it and argue whether there's something that's relevant for the Brian Walshe case and any criminal defendant that has these players, the same players involved, Michael Proctor, whatever it is, they should also have the same process in store. So we'll see if they watch Brother Counsel and join BCU, then they will have the answer to the question, and this is how the process should be going forward. Well, that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.